Welcome to today's episode of What Does the Law Say? Before we move on, please like, share, subscribe, drop your comments and your questions below. Thank you. In our last episode, we discussed about the rights and the obligations of a tenant in a tenancy agreement. In today's episode, our discussion will be centered on the rights and the obligations of a landlord in a tenancy agreement. What are the rights that a landlord has? What are his obligations in a tenancy agreement? That is what our discussion would be focused on today. So what are the rights of a landlord? Section 43 of the 1999 Constitution of the Federal Republic of Nigeria provides that every citizen has the right to acquire and own immovable property anywhere in Nigeria. So whether you're a landlord now or you hope to be a landlord in the future, you have a right as a citizen of Nigeria to acquire and to own property anywhere in Nigeria. Secondly, a landlord has the right to recover his premises. Section 26 of the Tenancy Law of Lagos State provides that the landlord shall be entitled to the recovery of premises where the tenancy agreement was a fixed term or where the tenancy agreement has already expired by reason of time. So if it's that you had an agreement for a year or had an agreement for 6 months and that agreement has expired already and you are not renewing it or you have not renewed it, then the landlord has the right to recover his premises. He's entitled to the recovery of his premises. So don't, because you know that you have a right to notice to quit and you have a right to the notice of 7 days owner's discretion to recover possession, you now say, okay, as a tenant, you're not going to leave the house even after your tenancy has expired. So if you have a tenancy agreement for a year and the tenancy agreement has already expired by reason of the time, it's over a year already, the landlord has the right to the recovery of his premises. Thirdly, where the premises of the landlord is required for personal use. So if for any reason or by any chance, the landlord needs to make use of his premises for personal use, the court has that power to make an order for possession of the premises. Subsection 2 of Section 25 of the Tenancy Law of Lagos State also provides that, notwithstanding any agreement that has been made between you and your landlord, or notwithstanding any agreement in a landlord and tenant relationship, the court shall have the powers to make an order for possession upon proof of the following grounds. Number 1, if the premises is being used for an illegal or immoral purpose, then the court shall have that power to make an order for possession. Secondly, if the premises is required for a purpose which is in public interest, then the court has the power to make an order for possession to recover these premises. At that point in time, it is not the issue of, oh, can my landlord recover his premises? That premises is supposed to be used for public interest. The purpose why he's trying to recover the premises is for public interest. So it is not going to be based on the agreements between you and the landlord. It will be based on the powers of the court to make an order for possession because that premises is supposed to be used for public interest. The third ground, if the premises has been abandoned, the court also has the powers to make an order for possession. A premises will be deemed to be abandoned if the tenancy has expired or if the tenant has not occupied the premises since the tenancy expired and has not given up lawful possession of the premises. The fourth ground upon which the court has the powers to make an order for possession, if the premises is unsafe or unsound as it constitutes danger to human life or property, then the court has the powers to make orders for possession. Obviously, you don't want to live in a premises that can endanger your life. So at that point in time, the court has the power to make an order for possession. Lastly, if the tenant or any person residing in the premises constitute a nuisance, whether by conduct or induces a breach of any agreement, the court has the powers to make an order for possession upon proof of these grounds that I have listed. A landlord also has the right to issue notice to quit. If for any reason he wants to terminate the tenancy agreement or the tenancy agreement has expired, the landlord has the right to issue the notice to quit. The landlord also has a right not to issue notice to quit. This can be possible if, for example, you enter into a tenancy agreement with your landlord and You sign the agreement hurriedly, desperately, because you want to, move into your new apartment, move into your new room, move into your new building. You don't proofread the agreement. You don't review the agreement. You don't consult a lawyer, a legal practitioner to help you proofread the agreement. And you hurriedly and desperately sign the agreement, not knowing that you've waived your right to issue notice to quit. Not knowing that you've waived your right to a notice to quit. Then the landlord will have the right not to issue a notice to quit because he's going by the agreements that you signed. So you want to be careful before you get into any tenancy agreement. You want to ensure that you review the agreement properly, or you consult your legal practitioner so you don't waive any of your rights as a tenant. So the only reason why a landlord will have the right not to issue you a notice to quit is if the tenant has waived his right to notice to quit. The landlord also has the right to issue 7 days notice of owner's intention to recover possession. So if after issuing a valid notice to quit and has been served properly on the tenant, and the tenant still refuses or doesn't vacate the premises, and the notice to quit has expired, the landlord has the right to issue the 7 days notice of owner's intention to recover possession. So as a tenant, don't be angry if you think that, the 6 months notice to quit has expired, and after that he just issued me a 7 days notice of owner's intention to recover possession. He has a right to issue you the owner's intention to recover possession as long as you've not vacated the premises. The landlord has the right to review rent. If in the tenancy agreement there's a rent review clause, then the landlord and the tenant can review the rent as long as it has been stipulated in the agreement how the rent is meant to be reviewed. Then the tenant and the landlord can review the rent. The landlord will have the right to review rent if there is no rent review clause in the tenancy agreement. So if for any reason you set your rent at this particular amount, you can't now come in 2 years and say that, I want to increase the rent just all of a sudden. No, there must have been a rent review clause. And if at all you are reviewing rent, it will not be on that subsisting tenancy. It will not be in that existing tenancy. It will be for the next tenancy agreement or for the next tenancy that hasn't started. Just like tenants have obligations, landlords also have obligations. So as a landlord, don't think, it's my property, it's my premises, pay and stay, I don't have to do anything. No, as a landlord, you also have obligations. Section 8 of the Tenancy Law of Lagos State provides for the obligations of a landlord. It is the duty of the landlord not to disturb the tenant's quiet and peaceable enjoyment of the premises. So daddy, thank you, sir. We know that you're a role model, and we know that we can look up to you, but please allow your tenants enjoy the premises peaceably, quietly. Let them enjoy the money that they paid for. When you want to do money devotion, it's not for your tenants, it can be for your family. If the tenants agree that they want to join you for devotion or join you for anything, then they can join you. But not because you think that, you're an elderly person or you're a father figure or a mother figure or a father or whatever you say you are. Now think that you can interfere and not allow your tenants to enjoy quiet and peaceable enjoyment. It is your duty as a landlord not to disturb the quiet and peaceable enjoyment of your tenants on the premises. The landlord also has the duty to issue payment receipt to a tenant. So after a tenant has paid his rent, it is your duty as a landlord to issue receipt. The Tenancy Law of Lagos State provides that any landlord that fails to issue payment receipt to a tenant shall be liable on conviction to a fine of 100,000 naira. Daddy wa. I don't think you want to pay a fine of 100,000 naira because you failed to issue payment receipt to a tenant for rent that he paid. So ensure, even as a tenant also, ensure that you receive your payment receipt, and as a landlord, it is your duty to issue payment receipt to a tenant. It is also the duty of a landlord to pay all rates and charges as stipulated by the law. So if there's any charge, any rate that is required of you as a landlord to pay, then it is your duty to pay it. Don't go ahead and say, my tenants have not paid me yet, so I won't pay it yet, or I don't have so much money. No, it is your duty, according to the Tenancy Law of Lagos State, that you are meant to pay all rates and charges as stipulated by the law for you to pay. There are obviously rates and charges that are stipulated by the law for the tenant to pay. So the one that is accrued to you, the one that you're meant to pay as a landlord, it is your duty to pay it. It is also the duty of the landlord to keep the premises insured against loss or damage. You don't want to move into an apartment or pay for an apartment and then 6 months later something happens, there's a fire or there's flood, and you ask your landlord and they say that we don't have insurance, or whatever it is that you lost has been lost already. No, it is your duty as a landlord to ensure that you keep the premises insured against any loss or damage. It is also the duty of the landlord not to terminate or restrict the use of a common facility or service for the use of the premises. So all those common facilities that are meant to be used by tenants in your premises, it is your duty as a landlord not to restrict it or not to terminate it. Don't say that you're trying to punish your tenants. You cut the NEPA lights, or you cut the wire, or you turn off the borehole, or padlock the tank, or something funny. No, it is your duty as a landlord not to terminate or restrict the common facility. Whatever it is that you've provided for your tenants to use together, to use commonly as tenants, it is your duty to ensure that it is there and you do not restrict it from them, and you don't terminate the use of those facilities. It is also an obligation of the landlord to effect repairs and maintain anything that needs to be changed, anything that needs to be repaired. Don't say that, oh, well, my tenants are working class. They can sort themselves out. They can pay. They can repair everything. They can do whatever it is. No, it is your duty as a landlord to effect repair and maintain the external and common parts of the premises. So if there's any part of the premises where it's external or it's common for everybody to use, or something like water, something like light, something like security, or the environment, the cleanliness, you want to ensure that you do your duty as a landlord. You effect those repairs and you make sure that you maintain common parts of the premises. Lastly, it is the duty of a landlord not to seize any item or property of his tenant or interfere with the tenant's access to personal property. So you are not meant to resort with self-help as a landlord. In conclusion, there are nice landlords and there are good tenants. People have all kinds of experiences though. Some people have had experiences of not so good a tenant or not so good a landlord. Whichever the case might be for you, whether now or later, please ensure you carry out the obligations stipulated by the law for you as a landlord or a tenant, and not just do whatever you think is ideal for you. Well, it is my house. Well, I've paid my rent already, so I will do whatever I like. No. As long as the law has provided for you duties as a landlord or a tenant, it is your responsibility to carry out those duties and not just do whatever you think is ideal for you or whatever you think it should be done. Also, it is important to note that if you're in a tenancy agreement that is not so favorable, consult your lawyer or consult a legal practitioner. It is important for you not to even get into any tenancy agreements without the consultation of a legal practitioner or a lawyer. If you're in a tenancy agreement where your rights have been denied, or you've waived all these rights, or you're even ignorant of them, it is time for you to consult a legal practitioner and seek redress, or in a way mediate and try and see if things can work out in a better way. My second advice for you as a landlord or as a tenant, ensure that you carry out all the obligations or the duties stipulated to you by law. Don't just do what you think is ideal. Ensure that you carry out all the obligations stipulated by the law. I hope you're able to learn something today. Thank you very much for listening. Please like, share, and subscribe, and drop your comments and questions in the comment section below. Thank you very much. I'll see you in the next episode. Bye.